So, as I understand the law, Mr. Gamble, they cannot penalize the client for being late. And the fees have to be associated with their damages. It has to be reasonable to those damages. The argument you're making is that in every case, someone can say, show me how you come up with $100 as your fee. That is not the way the law works. Now, it has to be reasonable. And in this particular case, I believe $100 is reasonable. I do take issue, Mr. Ingram, with the fact that there's a $10 late fee every day.
This hearing starts with confusion, missing ledgers, bounced checks, disputed fees, and a tenant already thousands behind on rent. The defense keeps arguing technicalities, but the judge is focused on one thing: who actually owes what. And once the late fees, bounce payments, and bankruptcy talk start piling up, the courtroom shifts fast, because the deeper this gets, the more the judge starts separating legitimate disputes from pure delay tactics.
All right, the court will call the case of Epic Property Management versus Diamond Edwards, case number 26C0995.
Good afternoon, Your Honor. Brent Ingram for the plaintiff.
Good afternoon, Your Honor. Andrew Campbell on behalf of the defendant, and I believe my client is present.
Please state your name, sir.
Diamond Edwards.
Thank you. All right, we're here on a partial motion for summary disposition.
Yes, Your Honor. If I may proceed.
I take it that the two of you have not been able to reach any agreements?
Not yet, Your Honor. I think we're getting closer to resolving this matter. But I think some of the arguments I'm going to be making, he will be objecting to.
I think in terms of a global resolution, Your Honor, there's probably going to be one that's forthcoming. However, in terms of what's before the court today, unfortunately, no. We do have a difference of opinion in terms of that.
All right, thank you. All right, give me one moment.
Sure, Your Honor. Thank you.
All right, you may proceed.
Yes, Your Honor. So, at issue before the court, Your Honor, is our motion for summary disposition, partial summary disposition as to some of these fees. And there's three sets of fees that we're disputing. There's been some confusion, and I apologize. The ledger, we didn't get a full ledger until a couple days ago. So, my forte is not math, Judge, so I'm going to do the best I can in trying to get this correct, because I have like 3 or 4 different ledgers, and then I got his, so I got a little confused. But the easiest one first, Your Honor, is the court processing fee. I believe that's in Mr. Ingram's response. He attached a letter. That's charged a $50 charge on February 23rd, 2026.
Okay, wait, well, let's slow down first of all.
Sure.
You mentioned an attached letter.
Ledger. There's a ledger that's attached to his motion response, Your Honor.
I don't think we got the attachments. You're talking about plaintiff, counter defendant's response to defendant's counterclaims, First Amendment counterclaim. That's what I have.
No, that's from the general civil case. This is the landlord-tenant case, and I realize it's a lot.
File. 1 second.
We did email the court this week, Judge, a response to this particular LT matter and this motion, along with an attachment that, as counsel indicated, is the most recent ledger up to date.
All right, one second. I gotta reach out to my clerk's office.
No problem at all, Your Honor.
One moment. They put the wrong thing in this file, and I need to have them come get this and bring me the file. Maybe that stuff got in that file. I'm not sure what's happening. Okay. All right, thank you. I apologize for the delay there. I wanted to read and catch up on where we were with things. All right, I have reviewed that and now you may proceed. You're muted though. You're muted.
Attorney Campbell, you're muted.
Sorry, Your Honor. I was referring to the ledger that the Mr. Ingram had filed, and I was pointing out the three types of fees. The simplest one to deal with first is the court processing fee on February 23rd, 2026. Your Honor, this is not in the lease agreement anywhere. The parties never agreed upon this. I looked carefully in the lease agreement, and this isn't allowed by law. It's a penalty. And my client never agreed to it. And even if my client had agreed to it, Michigan law doesn't necessarily allow these types of charges, especially when in the summary proceeding statute, the court has the authority to award costs. And the court's familiar with this. Sometimes it's referred to as the $75 statutory attorney fee. Sometimes there's a $150 fee for winning a motion. Sometimes there's a $300 fee for winning at trial, but I've never seen a court processing fee. We would object to that fee. The other two fees at issue.
Before we move on, I want to deal with them one at a time. So let's start with that one. So the court attorney fees that is here, it looks like.
Yeah, the court attorney fees, these are, I believe, charged for this case, Your Honor. Just so you know, Your Honor, you have some background. My client would at various times get demands for payment emailed to him, and sometimes they would have parts of a ledger. And since December, I've been asking for a complete and full ledger. When Mr. Ingram filed this case, he included a ledger up to, I believe, January 7th. And that was filed, I believe, with the court as well. But since then, I've been asking for ledgers, and we finally got one 2 days ago. And this ledger supersedes any other ledger because they all kind of differ a little bit. But there were court attorney fees for the December case that they lost that was being charged, and it looks like that's been removed. So these attorney fees, I think it's arguable that they're recoverable, so I'm not going to dispute them. I would dispute only ones from a previous case in which they lost that case. It was a CARES Act motion that they lost on.
May I respond?
Before you respond, I think I'm confused. Are you saying that you just said you weren't going to dispute them, but you're disputing them? I'm confused at what you're saying, Campbell.
When I drafted this motion, Your Honor, I was looking at ledgers that don't apply now.
The old ones, right? So
Yeah.
are you disputing these ones or not disputing these?
Not this set of attorney fees, no. Just the court processing fee, the $50 court processing fee. That's what I'm disputing.
All right, thank you. All right, Mr. Ingram, you may proceed.
Thank you, Judge. Just speaking to the fee that he's referring to, typically the way these cases are filed and the way the ledgers are generated, we always take out those and we do the statutory fees when we approach from the standpoint of a judgment. Some of that stuff is just automatic, but that's neither here nor there. We haven't received a payment since October of 2025. The payments that we did receive, there was a few that trickled in before the new year. They all bounced. And counsel, I respect that he's taking issue with certain, pieces here and there, and he's probably going to want to go through each and every one, but his motion calls for the elimination of all the fees. And frankly, that's not in accordance with case law or statute or really anything. I can understand caps, which many courts frequently do. They think certain fees are punitive at a certain point, and that's fine. But liquidated damages, and there are other arguments. These are arguments that are real, and we're bleeding money. My client has not received a payment since October of 2025, and so I mean, this is really just it's a small fish or small fry compared to the massive rental debt that is currently owed by this particular defendant. So
I
at this
agree with
point,
you. I agree with you on that part, Mr. Ingram, but I think what he's saying is you're not entitled to put a $50 processing fee on his ledger.
I would not object to removing that from a judgment, and I would even if he wouldn't have made that argument, because that's something, as I said, that gets just automatically generated by their system, and we never actually charge them that anyway.
All right. Your next fee, Mr.
Yes, yes, Your Honor. The next fee would be any NSF fees. And these were I believe the non-sufficient funds, and I'm trying to find them here because hang on, I'm sorry.
So I want to understand that they're entitled to charge a non-sufficient fund fee. In fact, your client could be prosecuted for non-sufficient funds. That's a crime.
He was prosecuted?
I say he could be.
Oh, well, that's actually, Your Honor, that's not entirely accurate. There is a statute on point here about NSF fees that they have to follow the statute. And the statute says you have to you have to put a specific letter together about the non-sufficient funds. That's argument number one. Okay, there's a statute that could.
The statute says you have to put a letter together for a non-sufficient fund.
Yes. Yes. That is 100% accurate. And if you want, I will get that statute for you if you just give me 1 second. I had it up.
What does the lease say about this non-sufficient fund?
You know, I'd have to go back and look, Judge, but our argument is always if the other side comes forward and says, hey, our bank charges us fees whenever your clients screw up and we have to pay those fees, that would be a good counter argument and a valid argument to make, but they never objected to these NSF fees in their motion response at all. As to what the lease says, Judge, I'd have to pull that up and look at it. It may have been discussed in the lease. And I'd have to pull up, if you just give me 1 moment, Your Honor, I will get to that.
Judge, my client is entitled to NSF fees. There have been multiple bounce checks. That's all the checks we receive were bounce checks.
Yeah.
I don't frankly completely follow what Attorney Campbell is arguing in terms of the
But he's talking about, so from what I understand, he's talking about the prosecution piece. In order to prosecute someone, you have to give them I did criminal defense. In order to prosecute someone, you have to give them a notice that there is a non-sufficient fee and give them an opportunity. That is completely separate than the fact that they can charge a non-sufficient fee for bouncing checks at a business. I'm not buying that argument, Counselor. Mr. Campbell, I'm not buying that argument.
Okay. Yeah. And my argument all along, Judge, just so you know, is look, if you can show you've been damaged, fine. Show us the proof you've been damaged, and now we can say you have actually suffered damages. But if your bank hasn't charged you money, how did you get hurt? You need to explain it. And what I mean by that, Judge, is, oh, well, our employee.
Mr. Campbell, I understand your argument. I don't agree with it. Okay?
Okay. I just wanted to expand because I want to make sure the court has. So the other fee, Your Honor, are late fees. Okay. I have a big problem with these. These are in the lease. The lease says it's $100 fee charged on the 4th of the month and then $10 for every day thereafter. Now, they didn't always charge these late fees. Again, we just got this ledger a couple days ago. So I went through and I itemized out all the late fees out. The court processing fee was $50. I'll throw out the NSF fees because you're not buying that argument from me. That's $150. So if we move 200, I'm objecting to $1,040 in late fees that I believe have been charged and that appear on this document. And I do that for a couple reasons. I'm not saying he wasn't late. What I'm saying is, Michigan law allows, people to recover actual damages when they've been harmed. But you have to show concrete harm and that you've been injured. And often what happens is landlords will come into court and they'll say, Your Honor, we have an employee who gets paid $25 an hour. They have to send 2 letters. It takes X amount of time to do that. That's why we charge these fees. Or, Your Honor, if I had that money, the time value of money, if I put that into a commercial bank account, I would generate X amount of money. Therefore, I couldn't do that because they didn't pay their rent. Therefore, I have suffered a loss of X amount. Those are valid counter arguments, but those arguments haven't been made. And those arguments were not made by opposing counsel. And if they had come forth with those arguments and come forth with that evidence of how they were actually damaged, I wouldn't be able to make this argument today. But these are egregious, and Michigan law would treat these as penalties, and you've got to prove your damages. The court knows this. In civil cases, you have to prove your damages, and I don't think they have. And that's why I'm objecting to this. And this is, I believe I said $1,240 was the amount plus the $50 court processing fee. So we object to $1,290 worth of these fees, Judge. And that's where we stand. And I'm happy to answer any questions the court has.
Mr. Ingram?
Respectfully, that's not the way damages work in a landlord-tenant context. I don't have to prove damages. The damages are self-evident. My client is allowing someone to stay in a space, perhaps, paying money to someone else. If the place isn't owned, a mortgage, whatever the case may be, they are being harmed if they're not receiving payments while that person is living there rent-free. Late fees are allowed in virtually all the district courts in Michigan in landlord-tenant contexts. So I'm not sure what Attorney Campbell is saying, that there has to be some new standard where late fees are not allowed unless you can show damages beyond the damages that are self-evident. The fact that we're not getting the payment for what we're providing. My client is providing with the defendant with a space to live and has since October of 2025 and earlier since they only took over in October of 2025, my client that is, and we're not being provided with anything. If that's not harm, I don't know what is. It's certainly not, what contractually my client agreed to. So we stand by our fees. I know different courts will have different criteria in terms of deeming them excessive, but that's a completely separate issue than saying, they need to be rejected whole cloth unless we show some sort of damages. I just don't think that's the way it works, and I don't find any of that persuasive.
So, as I understand the law, Mr. Gambold, they cannot penalize the client for being late, and the fees have to be associated with their damages. It has to be reasonable to those damages. The argument you're making is that in every case, someone can say, show me how you come up with $100 as your fee. That is not the way the law works. Now, it has to be reasonable. And in this particular case, I believe $100 is reasonable. I do take issue, Mr. Ingram, with the fact that there's a $10 late fee every day. That is not acceptable. That is not reasonable. That is excessive. So
Understood.
that I am not going to allow. But the $100 is pretty much standard. Yesterday I had one when someone was trying to charge $300. That was unacceptable as well. But $100 is a reasonable amount, given everything that someone is paying for collection efforts to collect their monies. In this case, $14,000 behind in rent is, other than these fees, what is in dispute? What is the tribal issue of fact here? I don't understand what we're having a trial about.
These were the issues, Judge. that were triable. That's the issues. These are the issues.
Right? So I suppose we can go back and calculate how to take out the $50 fee and all of those $10 fees, correct?
That's correct, Judge.
And figure out where we are and reach
Yep.
some agreement.
Yep, and I think we're very close to that, Your Honor. And Mr. Ingram and I have discussed that, and I'm pretty sure we can get a resolution here shortly. Because my client did file a letter with the court. I didn't know he was going to do that, but he asked for additional time. He's apparently filing bankruptcy tomorrow. So, but that's where we stand right now, Judge. But Mr. Ingram and I have been talking, and we've been, besides the ledger issue, because back in February when this case first started, it wasn't 14,000. I mean, it was, you could say it's 6, 7, or 8. Coming up with 4 to 5,000 is a lot different than coming for, if Hawk covers 3,000, is a lot different than coming up with, 13,000 or $10,000. But
on
Mr.
respect,
Ingram,
what I need to say about that is whose fault is that? He could have resolved this at any point in time.
Judge, Hawk will never pay and will never talk to you. SOS will never talk to you and never pay without a ledger. They require it. We've been asking for, I could document back in December I asked, January I asked, February I asked, March I asked, April. I've been asking the entire time. I got one 2 days ago. I had partial ones.
To get the ledger.
What's that?
I'm asking Mr. Ingram why it took so long to get you the ledger.
Ledgers were provided to Attorney Campbell. However, the ones that were generated didn't always show the entire rental history. It would be the most recent up until what's owed. And I believe that his issue was that he wanted one that showed the entire, all the way back to 2025 rental balance. If I understand correctly.
That is accurate.
But I don't think, frankly, that would have been necessary for assistance.
It would not have been. It would not have been necessary for assistance.
I've never heard that you had to have a complete rental history ledger to get assistance, so I don't even, frankly, really understand what that's about. But
that's my experience with SOS. I have interactions with them all the time. They're always wanting ledgers. Now, maybe it's SOS and not Hawk. I don't know. But I'm telling you that
he's not saying that you had a ledger. What he's saying is they didn't need the history to go back that far.
I did not, Your Honor. I think the court, there's a mistake here. The ledger he gave me 2 days ago differs from past ledgers. We have ledgers that go into like January, and from my memory, there were late fees almost every day in January, and they have been removed in this ledger. So the ledgers I were getting before were not accurate. If they're saying this is the accurate ledger, the ledgers I got before, and I can show you these, Judge. I'm going off of memory, but
that doesn't change the contention that Attorney Campbell is making, though. If late fees might have been removed that we advised would be deemed excessive, doesn't change the fact that he's arguing that he did not have a ledger, and because there was no ledger, he could not finish the assistance application. So I don't think these alleged alterations are relevant. You can say that you didn't have a quote unquote ledger because something was shifted or this was removed or that, but you either have a ledger or you don't.
Judge, I just want to address one point. In October, Epic took over this lease. And before that, JMZ Management was managing it. My client moved in July 1st. And when I got the original ledger from Mr. Ingram in the first case back in December, I told him, I said, I don't understand this beginning balance of, it says 0, but then it says my client made a partial payment of like $506. Yeah, it's 10-4. It's on the first page, I believe, of your ledger. 10/14, 2025, received at closing 567.37, and I believe that looks like they split up the month because they took over in the middle of the month. And I thought to myself, well, wait a minute, why would my client make half of a payment? This is weird. Where does this come from? And I wanted to see if the $608 charged had anything to do with the previous management company. That's what I was trying to get at, Judge, because I didn't know, I didn't understand how this didn't make sense to me because my client never paid like such an odd amount. He might pay like $500, $300, but I'd never see him pay a partial amount to this degree. It just didn't make sense. And that was one of the biggest issues we had.
Judge, the balance was at zero. All of the ledgers were at zero that Attorney Campbell was given, and he's literally taking issue with the only payment that his client made in the entire rental history with my client that did not bounce. Somehow that's a mysterious or questionable payment, and so he's asking for records from before we were in charge of the place, which we've zeroed out. So argument-wise, that doesn't even make sense to me either. Essentially, he's saying this looks fishy because of the payment that's credited to my client, so I need to see old stuff that's unrelated that might somehow shed some sort of insight into something. It doesn't even make any sense to me. It starts at zero. His client made one payment that didn't bounce. One. All the rest did. And there's some weird mystery around that calling for more documentation. It's just dilatory, and it makes no sense.
So, with respect to this request here for an extension of time, what is that about?
Your Honor, I believe my client can speak on that. Mr. Edwards? Can you unmute yourself, Mr. Edwards? Let me see. I'm sorry, Judge. He's in a class right now.
Okay, that's okay, I understand.
But anyway, Judge, I think he was, what happened, Your Honor, I just want to let the court know. I expected him to file last week. And he's hiring Frigo and Associates, and the attorney went out of town and couldn't get the filing done. I expected this to be filed already, like last week. And so, apparently the attorney's not coming back till tomorrow, and the earliest they could file is tomorrow. So he reached out to the court. I didn't ask him to do that, Judge. I didn't know, but that's what he did, and he chose to do on his own accord. So I don't want you to think I'm encouraging ex parte communications, because I'm not. It's just
Ms.
what
Murray,
happened.
it should actually go to Mr. Ingram so he can see it as well, because he has to.
Right, and I'm sorry about that. So I'll get that to him.
Okay.
It's just about his bankruptcy. If you can just give me a minute, I'll get it to him. So,
Judge, as
sorry.
you indicated, if we're going to sort the fee issue in the way that Your Honor, cut these up, I would just, at this point, I would orally move for a judgment for the amount less those fees, because as Your Honor said, and as Attorney Campbell even indicated, there is no tribal issue left. This was the whole rub of what's been stringing this thing along. And it appears that it's been sorted. So at this point, I would ask for a judgment. If Your Honor is not inclined to do that, I understand, but it's just more time. It's just
What I'm
more of a
going,
stringing along. More money that he'll owe, it doesn't make any
And
sense.
Judge, we have to resolve this motion, and we got to put forth an order to make sure that these fees are wiped out, the ones that you have found, the court processing fee and the $10 per day fees, I believe is what you ruled upon, Judge. And I'm happy to put that order together. But that has to be put into an order, and it has to be entered. So that's where we're at right now, Judge. He's going to get his what he wants here very shortly. And we were talking about a COD earlier in the breakout room. So
Well, this is what I'm gonna do. I'm not gonna do what either one of you wants. What I'm gonna do is I'm gonna put it over for 1 week, if we can do that. And you guys put your order together, make sure you have the correct numbers, and we all agree on those numbers. And when I come back here, when we come back here, I don't see a tribal issue of fact, and at that point, if you can't reach a COD or anything like that, that's where we'll be. So hopefully you can reach out some agreement before we have to come back here.
I think
All right,
that's an excellent resolution, Judge, and we will not object to that.
All right.
Thank you, Your
so,
Honor.
One moment, what time on?
Give me 1 second here, Hunter. We could either,
Attorney Campbell, can you prepare that order for today with those numbers?
Yes, sir. Yes, I'm gonna try to get that done today before I leave, and I'll email it to you, and we can talk if there's anything, because I'm not good at, I'm just being honest, my math is not so good. So we'll work it out.
I think if I understand the
at 3
judge,
p.m. Sorry, I tried to say that a few times.
oh, we'll talk.
You said 2:30.
2:30 or 3 p.m.
We'll do it at 2:30 next week, same time. So
Thank you.
May 28th, 2026 at 2:30 p.m.
Is that Zoom as well, Judge, or is that in
Yes.
person?
on Zoom.
Thank
Okay.
you, Judge, and I apologize. I interrupted the court, your clerk
It's
there. I
okay, it wasn't
apologize.
to the point that it really bothered me. You'll know if it does.
Okay,
Okay.
thank you, Judge. I appreciate your
Thank you.
patience.
Have a
Take
good
care.
day.
In the end, the judge trims the excessive fees, keeps the reasonable ones, and makes it clear this case is running out of road. The tenant may get another week, but the court already sounds exhausted with the delays, the ledger fights, and the shifting arguments. At some point, unpaid rent becomes impossible to explain away. Do you think the judge was fair, or did the defendant waste too many chances? Comment below, hit like, and subscribe for more real courtroom breakdowns.